Welcome to CM Guide podcast series. Today we're taking a deep dive into a topic that might sound a bit niche, maybe, but is absolutely foundational if you're involved in the built environment here in Singapore. We're talking about the Building and Construction Industry Security of Payment Act. You'll often hear it called the SOP Act. Ever wondered how construction payment disputes get sorted out, ideally quickly and fairly? Well, this deep dive is definitely for you. Our mission today is really to demystify this critical piece of legislation, give you a clear picture of what it is, how it works, and importantly, why it matters so much. So let's start right at the beginning. The SOP Act, it came into force, April 2005, with some updates later on?
That's right, 2005, and then, yes, significant amendments around 2018, 2019.
But what was the problem it was actually trying to fix? What was going on before 2005?
Oh, it was. Well, picture the construction industry's cash flow just completely clogged up. Before the act, particularly around the early 2000s, say 2002, the industry was facing really tremendous cash flow problems. You had this pattern of poor payment behavior starting at the top, and it would just cascade down the contractual chain.
Right, hitting everyone down the line.
Exactly. Subcontractors, suppliers, even consultants often ended up funding the work themselves, out of pocket, and then just waiting, sometimes indefinitely, for payment. It was a huge issue. So the act was brought in with two main goals, really. First, to give anyone doing construction work or supplying goods or services a solid statutory right to get paid for what they've completed. And second, crucially, to set up a fast, relatively low-cost way to resolve disputes over those payments, using independent adjudication.
So speeding things up and making it fairer.
Precisely. It aimed to improve cash flow fundamentally.
Interesting. And the commentaries mentioned Singapore was actually quite early in adopting this kind of statutory adjudication following the UK, Australia, New Zealand. Where did Singapore get the idea, the inspiration for its specific model?
Yeah, Singapore was the fourth jurisdiction. The model here is based quite heavily on the New South Wales legislation in Australia. And that, in turn, was largely inspired by a really influential UK report from 1993, the Latham Report.
Ah, the Latham Report.
Yes. It really shone a light on the unfairness often baked into construction contracts back then. Things like powerful parties just imposing these very one-sided onerous conditions in bespoke contracts. And a classic example, which the report highlighted, was the pay-when-paid clause.
Right, I've heard of those. Basically, you only get paid if the person above you gets paid.
Yeah. Exactly. So a subcontractor could do all the work, but if the main contractor didn't get paid by the developer, for whatever reason, the subcontractor got nothing, potentially for months or even years. It left them incredibly vulnerable. The SOP Act came in and specifically made those pay when paid and pay if paid clauses completely void and unenforceable. That was a major step towards leveling the playing field.
Okay, that makes the why very clear. Now let's talk about the who and what. Which contracts and projects does the SOP Act actually cover? Are there important distinctions, say, between construction and supply contracts?
Good question. The Act applies broadly, but it needs to be a written contract. It covers contracts for carrying out construction work, or for supplying goods or services for construction projects physically located in Singapore. Now, construction contracts, that covers the actual building work, obviously, but also consultancy services. Think feasibility studies, design work, site supervision, project management, even just providing labor for construction work. It also, interestingly, includes prefabrication of components. So even if components are made overseas but destined for a Singapore project, that contract can be covered. Or components made locally for an overseas project if both parties are Singapore-based entities.
Okay, so prefab gets included. What about pure supply contracts, just delivering materials?
Yes, those are covered too, but they're defined a bit more narrowly. It's for goods, materials, plant, components, equipment intended for a construction project. The key things are usually there's no significant on-site assembly or installation involved by the supplier, and the contract has to clearly identify the specific project or site in Singapore where those goods are going.
Got it. So clear link to a Singapore project. And to get the full picture, what's not covered, are there important exclusions people need to be aware of?
Yes, definitely some key exclusions. First, construction work that happens entirely outside Singapore, apart from those prefabrication scenarios we just mentioned. Second, it generally doesn't apply to very small residential projects, specifically those where the owner lives or intends to live there, and the work is minor enough that it doesn't require formal building plan approval under the Building Control Act.
So, like, a small home renovation probably wouldn't be covered unless it needed major approvals.
Exactly. Third, it doesn't cover employment contracts. This is for commercial contracts, not disputes between an employee and their employer. Fourth, work or services supplied after a contract has been terminated aren't covered. However, any payments you are entitled to before the termination date, those can still be claimed under the Act.
Okay.
And one really important point. The Act explicitly binds the Singapore government.
Ah, that is significant. So government projects fall under this too.
Absolutely, they have to follow the same rules.
Okay, let's unpack this. What about those tricky clauses we mentioned, like pay when paid? Can parties write contracts trying to get around the Act?
The Act is actually very wise to that. It has strong anti-avoidance provisions. Essentially, any clause in a contract that tries to undermine the Act or is inconsistent with its purpose is automatically void.
So you can't just contract out of it.
Nope. Clauses attempting to exclude the Act or making it harder for someone to use their rights under the Act, or those infamous pay if paid or pay when paid conditions, they're all rendered ineffective. As we discussed, those clauses cause huge problems for downstream parties, forcing them to carry disproportionate financial risk. The Act makes sure that can't happen.
And does it matter what law the contract says governs it? Like if it says English law applies?
Doesn't matter. If the construction work is carried out in Singapore, the SOP Act applies regardless of what the contract says about governing law. It overrides conflicting clauses. It's a powerful safeguard.
This raises an important question then. What kinds of payment disputes can actually be taken to adjudication under this Act? Is it for any money disagreement on a project?
No, it's quite specific. The Act is focused on claims up the contractual chain for what it calls progress payments. Now, progress payment is defined broadly. It can be a single lump sum payment, regular interim payments, payments triggered by hitting certain milestones, or even the final payment due under the contract.
Okay.
It covers payment for work done, consultancy services provided, materials or equipment supplied, agreed variation work. Even contractually agreed interest on overdue payments can be included.
But what's not included?
Right. Crucially, it generally doesn't cover claims for damages. So things like liquidated damages for delay or unliquidated damages for breach of contract or negligence, or claims for extensions of time, those are typically outside the scope of SOP Act adjudication.
Unless
the actual amount of those damages or losses has already been clearly agreed upon by the parties or formally certified, say, by a contract administrator.
So it keeps the focus purely on getting paid for work done or goods supplied, basically.
Exactly. That's why the adjudication process can be so fast. It avoids getting bogged down in complex arguments about losses and damages, which often take much longer to resolve.
That makes sense, keeps it streamlined. Okay, so let's walk through the process. If you're a contractor, a supplier, a consultant, and you need to make a claim, how does that first step work? The payment claim.
Right. Stage 1, the payment claim. This is the starting point. Anyone entitled to a progress payment, main con, subby, supplier, consultant, can serve one. There are strict requirements, though. It must be in writing. It has to clearly identify the contract it relates to. It needs to state the claimed amount, calculated by reference to a specific period or event. And importantly, it needs sufficient detail. What are the items of work or goods or services? Quantity, description, and it needs to be properly supported by relevant documents like valuations, delivery orders, invoices, reports.
And serving it correctly is key, I assume.
Absolutely. Proper service according to the contract or the Act is essential. Also, you can generally only serve one payment claim for each payment cycle defined in the contract. But if a previous claim hasn't been paid, you can repeat that unpaid amount in your next claim.
Is there a time limit?
Yes. There's a long stop date. You generally have 30 months from the completion of the construction work or the supply to make your claim related to that work. And there was a helpful clarification recently. Even if you serve your claim a bit before the date specified in the contract, it's usually still considered valid. It's just treated as being served on that due date. Gives a bit more flexibility. Timing, as some court cases have shown, can be absolutely crucial.
Okay, payment claim served. What happens next? What does the party receiving it, the respondent, have to do?
This brings us to stage 2 and the duty to speak. What happens next depends slightly on whether it's a construction contract or a pure supply contract. For construction contracts, the respondent must provide a formal payment response. This isn't optional if they want to dispute anything.
What does that response need to say?
It has to state the amount they propose to pay, which could be 0. And if they're proposing to pay less than the claimed amount, They must give clear reasons for withholding payment, explaining why for each item they're disputing, and provide a calculation or breakdown.
How long do they have?
The default period is 14 days from receiving the payment claim. That was actually increased from 7 days back in 2019, giving respondents a bit more breathing room.
And for supply contracts?
For pure supply contracts, it's slightly simpler. The respondent needs to either pay the amount by the due date or, if they dispute it, provide a written notice outlining their objections and reasons before that due date. The default due date is usually 30 days after the claim.
What if they don't respond properly or at all?
Big consequences. If you receive a payment claim and you don't raise an objection in your payment response or written notice for supply contracts, you generally lose the right to raise that objection later in adjudication or even in court if the claimant pursues enforcement.
Wow. Okay, so you have to state your case up front.
Absolutely. There are very limited exceptions, like for really obvious patent errors on the face of the claim, or maybe if circumstances justifying the withholding only arose after the response was due. But generally, silence or an inadequate response means you can't argue those points later.
Right. So let's say there is a dispute, either no response or a response that disputes the amount. What happens before you can actually lodge that adjudication application? You mentioned a sort of cooling off period.
Yes, for construction contracts, that's stage 3, the pre-adjudication steps. If the respondent fails to provide a payment response, or if they do respond but dispute the amount, a mandatory 7-day dispute settlement period kicks in. This starts the day after the payment response was due. It's basically a pause, a final chance for the parties to talk, clarify things, maybe negotiate a settlement before formally starting adjudication. It's a moratorium.
And if that doesn't resolve it?
If the dispute is still ongoing after that 7-day period, the claimant must then serve a written notice of intention to apply for adjudication on the respondent. This formally signals their intent to proceed.
Another notice. Timing critical again.
Yes, the timing for serving this notice and then filing the application is very specific, and there have been court cases clarifying exactly how to calculate those periods. For instance, one case clarified that the 7-day window to actually file the application starts the day after the entitlement to apply arises. Getting these timings right is vital.
Okay, notice served, dispute ongoing. Now the claimant is ready for stage 4. Applying for adjudication. How does that work?
The claimant now has a strict 7-day deadline, starting from when their entitlement to apply arose to submit the formal adjudication application. This application goes to the Authorized Nominating Body, or ANB. In Singapore, that's currently the Singapore Mediation Center, the SMC.
What goes into the application?
It needs to be a written request, accompanied by the application fee. It must contain details of both parties, the contract specifics, and crucially, copies of the payment claim, the payment response, if any, the notice of intention, and any other key documents.
And what does the ANB, the SMC, do then?
The SMC processes the application. They will then formally serve a copy of the application on the respondent. They also typically notify the principal, the owner or developer higher up the chain that an adjudication has commenced involving their project.
Right, application lodged. Now the ball is back in the respondent's court, and the adjudicator gets appointed.
Exactly. Stage 5 involves both those things happening quickly. The ANB, the SMC, has 7 days from receiving the application to appoint an independent adjudicator from their panel. At the same time, the respondent, having received the adjudication application from the ANB, has just 7 days to prepare and submit their adjudication response back to the ANB.
Only 7 days. That's tight.
It is. And this response is their main chance to formally reply to the claimant's application and provide all the reasons and evidence supporting their initial payment response, or explaining why they didn't provide one, perhaps.
What if they miss the deadline? Or try to raise new issues?
Late responses are generally rejected outright by the ANB. And remember the duty to speak. Any new reasons for withholding payment or objections that weren't in the original payment response will generally be disregarded by the adjudicator. They can usually only rely on what they stated initially unless it falls into that narrow patent error exception.
Okay, application in, response in, adjudicator appointed. Now we hit stage 6, the adjudication proper. How does the adjudicator actually decide? How long does it take?
The stage is all about speed. The adjudicator has a very short time frame to make their adjudication determination. Typically, it's just 7 working days if the respondent either didn't file a payment response at all or didn't pay an undisputed amount. In all other cases, it's 14 working days from when the adjudicator receives a response or the deadline for it passes.
Can that be extended?
Yes. The parties can mutually agree to give the adjudicator more time, or the adjudicator can request an extension, typically up to another 14 days.
And how do they conduct it? Is it like a mini trial?
Rarely. The adjudicator has broad powers to decide the procedure. It can be based entirely on the documents submitted. They might decide to convene a conference, usually via phone or video call, to clarify points. They could ask for more information or even conduct a site inspection if they feel it's necessary. Their core duties are to act independently, impartially, comply with natural justice principles, giving both sides a fair hearing, act efficiently and avoid unnecessary expense, and meet the deadlines.
What do they actually consider?
They look at the provisions of the SOP Act itself, the terms of the contract, the payment claim, the payment response, if any, the adjudication application and response, and any submissions or evidence presented. They cannot consider objections or reasons for withholding that weren't in the payment response, barring those patent errors, and they stick to the progress payment scope, no complex damages or time extension claims.
What about costs? Can you get your legal fees back?
Generally, no. The adjudicator can determine who pays the adjudication costs, which are the A and B's fees, and the adjudicator's own fees and expenses. But they typically cannot award the party's own legal costs or other expenses incurred in preparing for the adjudication.
And the determination itself?
It's issued in writing, states the amount to be paid, if any, the date it's due, usually within 7 days, and who pays the adjudication costs. And critically, it's binding on the parties unless and until it's overturned by a court or resolved differently through arbitration or a settlement.
Okay, here's where it gets really interesting, as you said, the teeth of the act. What if a party isn't happy with the determination? Can they challenge it? And if the losing party still doesn't pay up, how are these decisions actually enforced?
Right, this is crucial. While the determination is binding and payment is due quickly, it's not necessarily the absolute final word. It's often described as providing temporary finality or rough justice to get cash flowing. So, yes, there are ways to challenge it. First, within the SOP Act framework itself, there's the adjudication review.
A review? How does that work?
Either party can apply for a review if the original adjudicated amount, or the difference between the claim and the determination, is $100,000 or more. It's essentially a second look by a different adjudicator, or a panel of 3 adjudicators if the disputed sum exceeds $1 million. But here's a key change that came in. If the respondent wants a review, they must first pay the full adjudicated amount into a special trust account held by the A and B.
Ah, so they have to pay upfront even to get the review.
Exactly. This was put in place to stop respondents using the review process simply as a delaying tactic and to address concerns about whether the claimant could ever recover the money if the review failed. It ensures the money is secured. The review adjudicator then reconsider the case, usually aiming to decide within 14 days.
Okay, that's the internal review. What about going to court? Can you ask a judge to overturn it?
Yes, you can apply to the High Court to have an adjudication determination set aside. But, and this is a very important but, the court will not re-examine the merits of the payment dispute itself. They won't decide if the work was actually done properly or if the amount was correct.
So what do they look at?
They look for specific, limited grounds related to the process or jurisdiction. Things like, was there a breach of natural justice? For example, was the adjudicator biased? Or did one party not get a fair chance to present their case? Was there even a valid payment claim served in the first place? Did the claimant breach a really fundamental requirement of the SOP Act? Was there fraud or corruption involved in obtaining the determination? Or was there a patent error on the face of the record? This means an obvious, clear-cut mistake that you can see just from reading the determination and key documents without needing detailed evidence, like the adjudicator mistakenly applying the wrong contract or basing the decision on something clearly contradicted by the documents submitted, or maybe awarding payment when there is zero supporting material provided.
So it's about the fairness and legality of the process, not re-arguing the payment itself.
Precisely. And again, if a respondent applies to set aside a determination, they generally have to pay the unpaid adjudicated amount into court as security first. The courts have also shown they'll look closely if a respondent asks to delay enforcement, especially checking the claimant's financial health, as seen in cases where stays were granted due to concerns about the claimant's solvency, contrasted with cases where sufficient disclosure meant no stay was given.
Okay, so challenging is possible, but limited. What if the determination stands, review fails or isn't sought, court challenge fails or isn't brought, but the respondent still doesn't pay? What enforcement tools does the unpaid claimant have?
This is where the SOP Act really provides powerful options. First, the claimant can take the adjudication determination to court and register it as a formal court judgment debt,
And once it's a judgment debt.
Then all the standard enforcement mechanisms kick in. The claimant can pursue winding up proceedings against the company, get orders to examine the debtor's assets, seize and sell property, or use garnishee orders to grab money owed to the debtor by third parties, like banks.
Okay, standard court enforcement. What else?
Second, and this is unique to the SOP Act, the unpaid claimant gets a statutory right to suspend work or the supply of goods and services.
Suspend work completely.
Yes. And crucially, while the work is suspended, the claimant is not liable for any loss or damage suffered by the respondent due to the suspension. Also, any contractual deadlines or time limits affecting the claimant are pushed out for the duration of the suspension.
That's a powerful lever.
It really is. They must, however, resume work within 3 days once the outstanding adjudicated amount, plus any costs of suspension, is paid in full. Third, the claimant can try to get paid directly by the party above the respondent, the principal. So a subcontractor could seek payment directly from the main contractor's client, the developer.
Does the principal have to pay?
It's at the principal's option, but if they do pay the claimant directly, they can then recover that amount from the payment they owe to the respondent. And finally, for suppliers, if they've supplied goods that are still unfixed, not yet permanently installed, and haven't been paid for as per an adjudication determination, they can exercise a lien over those goods. Essentially, take possession or prevent them from being used until payment is made.
So, taking a step back,
Yeah.
looking at the big picture, what's the overall impact been? How has the SOP Act really changed things for the construction industry in Singapore since 2005?
Oh, it's been transformative, truly. It has significantly improved cash flow, which is a core objective. The introduction of this fast, relatively inexpensive adjudication process has provided a vital mechanism for resolving payment disputes quickly. You just have to look at the usage numbers. As you said, it started slow, maybe just one case in the first year, but since around 2014, we've consistently seen over 400 adjudication applications filed each year. The SMC reported that as of March 2024, they'd handled over 4,700 applications in total, covering claims worth over SR $8 billion. That shows a massive uptake in growing confidence in the system.
So it's become a standard part of the landscape.
Absolutely. It provides that rough justice, that temporary finality. It's designed for speed to get money moving, not necessarily perfect, detailed accuracy like you might aim for in full litigation or arbitration, which parties can still pursue later for a final determination. But for keeping projects funded and businesses afloat, it's been invaluable.
And looking ahead now, are there any further reforms expected? Any tweaks on the horizon for the SOP Act regime?
At the moment, nothing major seems imminent. The last big round of amendments in 2019 was quite comprehensive, aimed at refining the process, adding certainty based on years of operation and court decisions. Those changes seem to have bedded in reasonably well. Of course, the Building and Construction Authority, BCA, keeps an eye on its development, and the Singapore Mediation Center continues its role in administering the scheme, training adjudicators, and publishing helpful statistics and practice notes. I think the key takeaway, reinforced by court judgments over the years, is just how critical it is for all parties, claimants and respondents, to understand and strictly follow the procedural requirements and timelines. Dotting the I's and crossing the T's is absolutely essential to make the system work effectively.
Well, this has been incredibly insightful. We hope this deep dive into Singapore's Security of Payment Act and Statutory Adjudication has given you, our listeners, a much clearer understanding of how these crucial payment disputes are handled in the built environment sector here. Whether you're on the paying or receiving end, knowing how this works is just vital for navigating construction projects successfully. It really underscores that old saying in construction: cash flow is king, and the SOP Act is a key part of keeping that kingdom running. Before you go, please don't forget to share, like, or subscribe. Also have a look at other episodes and visit CM Guide website for better insights on this topic.